Good morning, Facebook. Good morning, YouTube. And good morning, Instagram. Just going to wait for you guys to tune in. While you do that, I'm going to put in my phone number so I can pin it in. Good morning. If this is your first time tuning in, definitely comment. Let me know where you're tuning in from. Even if it's not your first time, still let me know where you're tuning in from. I hope you guys enjoyed your day off yesterday. I have a good topic today. Okay, so let me just pin this. Pinned. Okay, so it's pinned. All right, Instagram and Facebook. So today I want to talk about, well, I guess before I start talking, let me introduce myself real quick. My name is Aisha Chidole. I am an immigration lawyer. I present clients all over the United States with their family immigration. We have an office in Atlanta and in Orlando, Florida, but our location does not matter. It doesn't matter where you live. We can still represent you with your family immigration as it pertains to the United States. Hey, Alabama in the house. And I see a first timer here from Houston, Texas. Muyu, thank you for tuning in. Monday Brown from Indianapolis, thank you for tuning in. My number is scrolling through the ticker. It's the 407-995-6567. You can also send a WhatsApp to 404-333-8751. It's pinned on Instagram. If you're catching this live, after it's been live, you can find it in the profile. Same thing on Facebook and YouTube. It's scrolling on the ticker, and you can also find the profile. Monday, thank you so much. I appreciate that. Today I want to talk about, what happens when you have a spouse who's an abuser and that spouse passes away. Are you still eligible for VAWA or if you're in the process or if you never filed it? But let me quickly explain for the first timers here again. VAWA is an act that allows spouses, children, or parents to get a green card based on abuse that has taken place in that relationship, either with their spouse, with their child, or with their parent. For spouses, if you're married to a US citizen or a green card holder, you are eligible for VAWA if your spouse has been abusive to you. If you're a parent, you're only eligible if your child is over the age of 21 and that child is a US citizen. You're not eligible if the child is a green card holder. You must be a US citizen for you to be eligible. The third one are for children. You're eligible as long as your parent or step parent is a US citizen or green card holder and you're under the age of 21. If you end up, let's say you found out about VAWA, you couldn't file VAWA until after the age of 21, you have an absolute deadline where you have to file it before 25, but we have to show reason why you filed it so late. So now that we have that out of the way, I want to talk about just filing. So I'm going to break it into two categories. So if you haven't filed your self-petition, meaning you haven't filed a valid petition, and your spouse passes away. If you haven't filed a self-petition, meaning you haven't put any papers on immigration, and your spouse passes away, if your spouse was a US citizen, you have up until 2 years to submit that petition. So for instance, if let's say your abusive spouse or your spouse has been extremely cruel to you, passes away maybe in 2020, or passed away in 2020, you have up until like May 2020, you had up until May 2022 to submit that petition. Otherwise, you're no longer eligible. This is the tricky part, so pay attention. If your spouse was a green card holder, right, you're not eligible. Okay? So if your spouse was a green card holder, you're not eligible for that. So only for US citizens. Also for children, you no longer are eligible if your parent that was abusive, or as a US citizen or green card holder passed away before you submitted the petition. Okay? Now, what about in a situation where you already put in your petition and then while your petition was pending, your spouse passes away, and stuff like that? So if you already put in your petition, whether you're a green card holder or a U.S. citizen, and your spouse passes away, in that case, it doesn't matter. You will still be eligible to continue the process, and all your derivative children will still be eligible to obtain the same benefits that you do. And for those of you who don't know what derivative children just basically means that all the children that are under 21, whether they live here in the United States with you or live in a different country or never lived with you and your abuser, those ones become eligible. So those are the things that I wanted to talk about, as it pertains to death and marriage. So let's see what questions you guys have. I have a question from YouTube. The person says, can someone who filed for VAWA and the spouse passes, what are their chances? So I'm sure you just heard me talk about if you already filed before your spouse passed away, you can continue the petition. But if you're asking what your chances are from approval, what is used to determine your chances are what you submitted in your application. So ultimately, without seeing your application or what was submitted, I can't really say, oh, what are your chances? But really, at the end of the day, as you all know, immigration is truly something that's subjective. This decision is made by USCIS. So, we can say we think you have a strong chance, or sometimes I can see, you might not have a strong chance and you might be successful. So it's really hard to say or give like a percentage. Okay, let's see what we have here on Instagram. Before you get into that topic, how long does immigration reach out to you after the submission of your papers? So what do you mean reach out to you? Like that you hear from immigration at all? Well, the first thing is that, once you submit your papers, you first get a filing receipt. Depending on what you filed, most filing receipts can take anywhere from, 3 weeks to like maybe 2 to 3 months. If you paid for something, like if your filing required a filing fee, most likely within 3 weeks to 6 weeks, you should get a filing receipt. The cases that we see take a long time to get a filing receipt are cases like when you do a VAWA self-petition, standalone, meaning you don't submit an adjustment of status application, therefore there's no fee that was paid. It's ridiculous, but we see like 3 month, 4 month delays. And, this never used to happen. This is something that's more recent. After that, depending on what case you have, the progression is different. So I don't know what your case is. So I can't say what the next step is, but that's kind of what the first thing you should get. So Kiara on Facebook says, good morning, Aisha. Will your spouse be notified if you file for VAWA? I'm scared. So Kiara, I understand. I completely understand your fear. And because of that, that is why USCIS instituted a policy where not only can a USCIS officer never notify your spouse, but also if you have a spouse who tries to write a letter to discredit your relationship or to discredit you, or even your abuser's in-law writes a letter to discredit you or whatever your marriage is, USCIS cannot take that evidence at face value. So generally there is a fine for a USCIS officer if they accidentally disclose that. So generally they don't do that. Normally when you submit a VAWA case, they always ask for a safe address, okay? If you're working with a lawyer, a lot of lawyers will allow you to use their offices, as safe address where they can mail it. And then, in our office, for instance, like we'll ask you where can we mail your stuff to? Give us an address. For some of our clients, they just get like a private like UPS or USPS mailbox. I think it's like $10, $20 a month, but just so that, they can receive their mails there. And then what else was I going to say? So yeah, so they generally will not know. One thing I will also say to you, and this is just just in terms of observations over the course of doing this area of law. If you live with your abuser, or if your abuser has access to your emails and They can easily get stuff like that. When you're submitting a VAWA petition, we as attorneys can do our own part of maintaining your confidentiality. So can USCIS, but you too have to be confidential. Like if you're hiring a lawyer, for example, don't go using an account, a bank account that you and your spouse share, or something like that to like pay your lawyer to pay for USCIS filing fees, because obviously they have access to that. Don't go using an email that they can log into. Don't leave your computer open. Change your email. Create an email address that they don't know about, so that they don't have access to it or whatnot. If you live, you just basically have to also take care to make sure that you're being discreet about what you're submitting. Okay. So Lene says, is adjusted gross income needed to sponsor a parent different for active duty military sponsors? No, it's not. Just follow the I-864 poverty guidelines, and it goes based on family size, and basically everybody has to meet what's listed in there. Okay. All right. Let's see what else we have here. Maxine Medwinter says, can my son file for me with his green card? This is a very good question. We get this question asked all the time, but the answer, unfortunately, is no. A son cannot file for a parent as a green card holder. In order for him to file for you, he has to be a U.S. citizen. So determine how long he's had his green card. If he's had it for up to 5 years, he can definitely file for citizenship. Once he becomes a citizen, then he can file for you. Okay? All right, let's see. When you put in your filing, how soon do you get a work permit? Well, what filing did you put in? So it varies depending on what you put in. If we're specifically talking about VAWA, since that's what today's topic is about, once you put in your filing, if you put it in with an adjustment of status application and a work permit in the right category, normally we see about 5 months to 9 months when we receive our EAD. Now we're seeing at least 50% of our clients are getting it around like 4.5, 5.5 months. There are always going to be some people that will get it later and even earlier, but like that's the window that we've seen over the last 2 months. So I want to believe that that's kind of a new trend, that they're processing things quicker since they moved over the renewal extensions. Okay. So Chris Sai says, my paper has been submitted from June and I haven't received anything. My husband is filing for me. So you have a regular marriage-based case, which means that there was a filing fee. If that was submitted in June and you don't have a receipt, I'm concerned definitely. You want to make sure that one, you submitted the right fee. Two, if you didn't submit the right fee, that's probably why you're seeing a delay. What really sucks is that if you send something wrong, it can take several months or several weeks for USCIS to return the whole packet back, and then you have to start again. So there's a possibility that happened. One of the things that you can do is you can just check if your husband used like a check, just get the number of the check and check bank statements to see if USCIS has cashed it. If USCIS has cashed it, then you know that it's just a delay in you receiving the receipt. If USCIS has not cashed it, then be fully expecting a return of your entire packet. Francois says, COVID messed up everything. I know, right? Very annoying. Suleiman Ghazal says, does VAWA affect your spouse in any way when you file? No, VAWA does not affect your spouse. So it's like what I just said in the beginning about confidentiality. The only way that it can affect your spouse would mean that they would have to disclose to your spouse that you submitted something. Do you understand what I'm saying? But they cannot disclose that. So it cannot affect your spouse because it puts you at risk. So USCIS cannot do that. So USCIS does not disclose anything. Your spouse is never going to know anything that happened. If your spouse gets into trouble for their own reasons, then your spouse will get into trouble for their own reasons. But what you're filing does not affect your spouse. Everybody says, good morning, attorney. Looking beautiful today. Thank you. How long does it take to get a prima facie letter? Honestly, this question I get asked all the time. A prima facie letter, let me first say this. A prima facie letter is not a receipt. So it's not a right. It's not a right. It's only if USCIS feels that you're eligible for it that they'll give you one. Prima facies can take anywhere from like 3 months, to whenever USCIS sends them. Sometimes, we've seen this happen. Sometimes USCIS will issue a prima facie letter and they won't send it till 5 months later. And when we get it 5 months later, we'll see the date was from like January, and it's like, why did you guys keep this stuff and not send it? Because sometimes USCIS, like everybody else, make mistakes or forget to do stuff. So it just really depends on how long you've been waiting. If you've been waiting, it's been like 9 months or whatever it is, maybe you can write a letter just to see, because here's the thing: if they're not going to give you a prima facie letter, then they should at least give you an RFE, which is a request for additional evidence, to say why they can't give you the prima facie yet because you need to satisfy X, Y, and Z. So that's how it works. Okay. Okay, so someone said, is paperwork moving faster now that we almost got over COVID? I wouldn't say so. I would say that interviews for marriage-based cases, for example, are taking the longest that we've ever seen them take. Even during the height of COVID, it just seems like it's taken a much longer time. Like interviews are not being scheduled for like 13 to 15 months. Naturalization is a mixed bag, same 13 to 15 months. And then we have some, 5 months. So it depends on your field office, the backlog of that field office. Consular processing is literally at a standstill, meaning it's really, really slow. Like that is not moving fast. As far as VAWA cases are moving at the exact same pace. At the exact same pace that we're like, right before pre-COVID, when it was like 18 to 24 months. Right now it's, 24 months to 2.5 years, but still all within the same window. The only thing that I've observed that's moved quickly in the last 2 months, like I mentioned, are seeing more work permits getting approved quicker. Okay, so Andrew Lopez says, I did not send anything and my lawyer did not send anything to. So why is it even like this? Even they did not ask anything to send reply just last year. I don't know what, is this a follow-up of another question? Because I'm not sure what this is in reference to. Okay, I see what it is. Your other mail came before. It says, my I-360 states, says correspondent was received at USCIS review, but me and my lawyer did not send anything. I believe you asked this question, or maybe it wasn't you that asked this question last week. USCIS has been making that mistake on a lot of the online portal. So that's why we don't really pay attention to the online portal. We pay attention to what we receive in the actual office. So if you didn't send anything and your lawyer didn't send anything, it's probably nothing there. It's just an error. Another thing as a point of caution is that because there was a period this year where Vermont somehow sent things to Lee Summit, who normally processes marriage stuff, to start processing like VAWA stuff, and they were making a ton of mistake. And so they sort of sent it back. So you might be dealing with the backlog of that or the error from that. But also another thing to point out is that if you see on that online thing where it says, we sent you an RFU on XX date, you never receive the RFP, what you want to check is your prima facie determination letter. If your prima facie determination letter is the same date as the date that they're saying that they sent you an RFP, that's what they're talking about, meaning it's not an RFP, it's an error. We've seen this a lot. So if that's the case, so that you don't panic. Okay, so let me see what other questions here. Carrie Love says, can I withdraw my VAWA application and get remarried to a U.S. citizen? If you want to, you can do that. Personally, I wouldn't, but that's my personal opinion. Instead, I would just date that person until my VAWA case is approved. Reason being, you don't want to be in the same situation again. And then this time, you basically lost out on getting your green card on your own self petition and you're at the mercy of your other spouse. So it doesn't stop you. Having a VAWA petition doesn't stop you from being in a relationship, but there's no rush to tie the knot. So if it was me, I will wait for my VAWA so that nobody can ever use them filing for me as something to hang around my head. But you're entitled to do what you want to. The question is, are you allowed to withdraw? Yes, you can withdraw if you want. How do I get my son from out of state? I'm married to a U.S. citizen. What do you mean out of state? What state is he in? I don't know. Maybe speak to a family lawyer. I'm not really sure what your question is. Chris says, is it possible to change immigration lawyers? Yeah, people change immigration lawyers all the time. For every lawyer, they're going to decide whether they're going to take the case, just like what doctors, depending on at what stage you come to them. Like when you're pregnant, most doctors will not take new patients if they didn't do their prenatal care with them. It's the same way with lawyers. Like, for instance, if you have a VAWA case and another lawyer has submitted your stuff, for me, it will depend on where we are on the case, what needs to be done, your immigration history, and evaluating before I can accept a case that another lawyer filed. Ms. Decor Dova Love says, is it normal not to get a work permit after you submit your VAWA and your I-485? Well, there's no normalcy or non-normalcy. It just depends on what you filed. Did you file for the right work permit? If you did, then you should get one. Austin says no volume. Can you guys hear me? If you're on Instagram, can you hear me? Comment and let me know if you can hear me on Instagram because he says he can't hear me. Tyler Dan says, can you get citizenship through VAWA? Yeah. So you don't get citizenship through VAWA. What you get is a green card. But when you're approved for VAWA, 3 years later, you can file for citizenship. So that's how it works. And that's how you get your citizenship. PCB Business News and More says, hey, attorney, I filed for VAWA with my kids. Can I apply for food stamps or just wait for the prima facie letter? My kids were the only ones who got their I-765, 131s, and socials. What do you think? You can apply for food stamps. Normally, when you're filing for immigration petition, they don't want you to take public benefits. But VAWA, there is an exemption for VAWA because they also understand that for a lot of people, that's the only thing that can help them leave or get out of situations or relationships that are dangerous for them by allowing them free access, but it's also state specific. So you want to find out from, your state what public benefits you're available for. But if you're eligible for food stamps in your states, then you can definitely apply for it. It's not going to affect your VAWA case if that's what you're concerned about. Thank you, PCB Business. Maxine Medwinter says, my mom is a citizen. Can she file? And how long does the process take? I assume you're asking me whether she can file for you. So the question is, are you over the age of 21? If you're over the age of 20, if you're under 21, she can file right away, because you're an immediate relative. Meaning, and I don't know where you are, what country you're in, or whatever it is. If you're over the age of 21, then it's broken down into two categories: married sons and daughters, and unmarried sons and daughters. If you're unmarried, the time is shorter. You're looking at 6 years. If you're married, you're looking more like 10 years. So that's kind of the timeline for you to get your stuff. Uchina Eze says, I got a receipt notice from VAWA in January of 2022 after filing January 2022, and since then no other information from USCIS. So maybe by now you can just do an inquiry and see if there's anything else they need to make a prima facie determination in your case, since it's been about 8 months. Okay, wait, I have some questions in here. Let me see if I can answer one of them. I'm age 23. First of all, let me just point out, I love how you structured your question. Now, this is somebody that's giving you the full scenario so that it can help me to answer your question. So you're age 23, you're here on a B1, B2, which is the same thing as a tourist visa or a visiting visa. My parent is a legal permanent resident, a green card holder. They already filed an I-130 in 2021. If I remain in the country, is this petition still valid? The I-130 is still valid, but you're not going to be able to get a green card through adjustment of status if you overstay your time. The only way for you to get a green card when when you're over the age of 23 is to be in legal status at the time visas are available. Because your parents are LPR and you're age 23, you're looking at probably I'm trying to think, I can't think of it, like 6 to 7 year timeline, 6 to 7 year timeline, or maybe 5 to 7 year timeline. So I'm assuming your tourist visa is only valid for 6 months, which is the norm. So, one option that maybe might be good for you is that you're 23, so you're still young. You can try for applying to school. Maybe apply to school and then change your status. So you can have an F1 student visa. And then when you're in the F1 visa, do a STEM major, which is science, technology, engineering, or math. So you do 4 years of college. You have OPT opportunity, which is occupational training when you finish, and that's for an additional 3 years. So that buys you time of 7 years if you choose to stay here. But do not stay here and overstay your status without a plan, because if you overstay your status without a plan, you're not going to get a green card in 7 years when your I-130 is approved, because you're no longer in valid status. And what you have to do is have your parents get, file a hardship waiver based on your parents. If that is approved, then you have to go back home to your home country before you can come back with a green card. So I hope that makes sense. But you have to be very strategic, in making sure that you're creating legal paths and that you're not out of status if you want to be able to stay here. Okay. So Ashley says, is it safe to travel on advanced parole, but my VAWA case is pending? If your VAWA case is still pending and you have advanced parole, and you've never filed any immigration petitions, you've never been put in deportation, you've checked EOIR for your alien number to confirm that there's no proceeding with your name, then it is okay to travel and come back. Okay. All right. How long does it take to get a fiancé visa approved? The timeline is dependent on the country you're from. We see some countries it takes 8 months. Some other countries it could take 15 months, 16 months. It just depends on what country you're from. But with the fiancé visa, you first of all have to get the I-129F approved here in the U.S. And then once you fill out your application for consular processing, it's a question of scheduling. Does the consulate have scheduling available? Like, for instance, I can tell you that for a fact Cameroon has availability. So if your fiance is, in Cameroon or something like that, they have scheduling availability. But then using a country like Ghana, there's a longer line, and that can take time. So it's really dependent on the country. All right, guys, I enjoyed chatting with you. I gotta jump off. I'm not going to be able to be on this Friday. I'm busy that day, but just comment in the comment and let me know what you want me to talk about, and I'll try to talk about it on my next live. I hope you guys have a wonderful, blessed week. If you want to schedule a consult, call us 407-995-6567. Don't just be waiting for live and not sure how to ask your question. Whether you choose to hire me or not, that's fine. You don't have to hire me, but at least schedule a consult and get peace of mind and, good legal advice for your particular case. Okay. All right, guys, have a great day. Bye.